proceedings in contempt and reject any and all outcomes.
About a dozen protesters, I don't think any of them were actually UAlbany students, outside of UAlbany yesterday. We're talking, of course, about the UAlbany CDTA bus case where the three students have now been criminally charged. There was a student conduct hearing, though, at the university yesterday. And we're joined now by our legal analyst, Paul Harding from Martin Harding Mazzotti. Hey, Paul.
Hey, good morning, guys.
So this is a weird thing. These protesters, and some others, their attorneys certainly, contend that they shouldn't be compelled, or they shouldn't have held this hearing because the criminal case is still pending. What's the story behind this? What are the legalities?
Well, there's an argument that things that are said at this disciplinary hearing and evidence which is uncovered can be used at a trial or a civil trial. So they sort of took the approach and said, listen, we're going to say that we're just going to sit this one out. You guys have the ability to render a decision without us there. We weren't going to say anything anyway, and therefore they didn't show.
I understand the concern here where there's two separate proceedings and the university comes up with their findings and their decision about what kind of disciplinary action to take, and then the court proceedings where it's criminal and they decide what will happen with that. So what happens if the criminal case, they go to the administrative case first and say they decide, you know what, you violated our code of conduct, we're going to suspend you from school. And then the court case resolves itself and they, for some reason, say, you know what, you're not guilty, and nothing sticks. So then the school has already disciplined them for something that the court found them not guilty of.
Yeah, there's a complete, different approach here. You've got a different burden of proof, and you have different rules that would allow you to either stay in school or not in school versus the criminal element to this. So this university has what they call accountability hearings, and it doesn't take a whole lot there in order for you to be found in violation of that, and usually resulting in a suspension. We'll see what happens here. So the criminal piece, completely different. Sure, they could be exonerated and still have the penalty imposed upon them by the university hearings.
I want you to hear this, Paul. This is James Acker. He's a criminal justice professor at UAlbany, and he kind of explained why they have to have the hearing now.
It would be a curious policy to require the university, in a serious matter, to wait and wait and wait indefinitely.
What do you make of that? I mean, cases can drag on a year or longer.
Well, they have right in their bylaws, when you kind of sign on for the school and you say, I want to go to University of Albany, they actually have this located right in the student handbook. It kind of says, we can do this, we will do this. It doesn't say that if you have criminal charges pending, and then let's take this a step further, criminal charges pending that really, to some degree, involve the university, right? So this is unique. But no, in the handbook it says we're going to do this thing, and we're going to do it within X number of, as it says, practicably reasonable in the handbook, but within a few days or a few weeks of an event. They did provide the attorneys with the information that they had just 2 days before, pursuant to their rules. And I guess if they just delayed this thing another year or two, you got people wandering around the university that they don't want on the university, if in fact, again, these girls are found to be suspended or thrown out of school. Now,
the decision is expected in a couple of weeks, but that's not going to be made public. I guess it's confidential. Would the DA, if he wanted to use whatever testimony there was, would a DA be able to get that information, or would that also be confidential?
The hearings are confidential, but people at the hearings can communicate what they've heard. So there's not a transcript that the district attorney can just go ahead and get. But again, information that comes out, you've got that the students were there. I mean, it's usually the advantage to the students, right? So had they been there and their attorneys had been there, they would have heard the case against them. They then would now know. They then could use that in a defense. I don't think that David Soares or any of the prosecution is going to rely on anything that was said at the hearing.
So one of the students has withdrawn from the university. Is it worth pursuing this in the academic side in case she decides to re-enroll, or should they just let it go?
Again, tricky question. Don't know. I think that they just looked at this a little too hot to handle. The attorneys made excellent points, self-incrimination. I do think that having your client not testify this is not necessarily a bad idea. Mm-hmm. Attending, I think, is a good idea. With that said, we'll have to wait and see.
Yeah, interesting and complicated case. Paul, thanks.
Thanks, guys.
Paul Harding, Martin Harding Mazzotti, our legal analyst, 1-800-LAW-1010.